Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in Starbucks Corporation v. McKinney. In this case, the court considered this issue. What test must courts use to evaluate requests for injunctions under Section 10J of the National Labor Relations Act? The case was decided on June 13, 2024. The Supreme Court held that when considering the NLRB's request for a preliminary injunction under Section 10J, district courts must apply the traditional four factors articulated in Winter v. Natural Resources Defense Council Incorporated. Section 10J authorizes a federal district court to grant such temporary relief, empowers courts to grant equitable relief. There is a strong presumption that courts will exercise that authority in a manner consistent with traditional principles of equity. For preliminary injunctions, the four criteria identified in Winter encompass the relevant equitable principles. Nothing in Section 10J displaces the presumption that those traditional principles govern. The traditional rule is that a plaintiff seeking a preliminary injunction must make a clear showing that he is likely to succeed on the merits, that he is likely to suffer irreparable harm in the absence of preliminary relief, that the balance of equities tips in his favor, and that an injunction is in the public interest. These commonplace considerations applicable to cases in which injunctions are sought in the federal courts reflect a practice with a background of several hundred years of history. When interpreting a statute that authorizes federal courts to grant preliminary injunctions, the court does not lightly assume that Congress has intended to depart from established principles. Absent a clear command from Congress, then, courts must adhere to the traditional four-factor test articulated in Winter. Section 10J's statutory directive to grant injunctive relief when the district court deems it just and proper does not jettison the normal equitable rules. It simply invokes the discretion that courts have traditionally exercised when faced with requests for equitable relief. Furthermore, Section 10J's text bears no resemblance to the language that Congress has employed when it has altered the normal equitable rules. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Thomas delivered the opinion of the court. The National Labor Relations Board can bring in-house enforcement proceedings against employers and labor unions for engaging in unfair labor practices. Section 10J of the National Labor Relations Act authorizes the board to seek a preliminary injunction from a federal district court while these administrative enforcement proceedings take place. The question in this case is whether the traditional four-factor test for a preliminary injunction governs the board's requests under Section 10J. We conclude that it does, and therefore vacate and remand. The National Labor Relations Act, NLRA, prohibits employers and unions from engaging in certain unfair labor practices. The National Labor Relations Board enforces that prohibition. The board's authority begins when a person files a charge with the agency alleging that an employer or labor union has engaged in an unfair labor practice. A regional director then investigates the charge. If the charge appears to have merit, the director institutes a formal action against the offending party by issuing an administrative complaint. This complaint triggers adjudicatory proceedings within the agency, first before an administrative law judge, and then before the board itself. A federal court of appeals may review the board's final order, if an aggrieved party seeks judicial review or if the board seeks enforcement of its order. On review, the board's findings of fact are conclusive if supported by substantial evidence. Because the board's administrative proceedings take years, Congress vested the board with authority to seek a preliminary injunction in federal court while the proceedings unfold. Section 10J of the NLRA provides that, upon issuance of a complaint, the board may petition any United States district court for appropriate temporary relief. A district court considering a Section 10J petition may grant to the board such temporary relief as it deems just and proper. Starbucks is the world's largest coffeehouse chain, with over 34,000 locations. In 2022, 6 employees at a Memphis, Tennessee, location announced plans to unionize the store and formed an organizing committee. Several employees, including some members of the organizing committee, invited a news crew from a local television station to visit the store after hours to promote their unionizing effort. The news crew interviewed the employees about their reasons for organizing and what they hoped to achieve. The next day, store management learned about the media event and launched an investigation. Starbucks ultimately fired multiple employees involved with the media event for violating company policy. These included the members of the organizing committee who were in attendance. The union coordinating with the employees filed charges with the board. The union alleged that Starbucks unlawfully interfered with the employees' right to unionize and discriminated against union supporters. After investigating the allegations, the board issued a complaint against Starbucks. The regional director then filed a Section 10J petition in the United States District Court for the Western District of Tennessee, seeking a preliminary injunction that would, among other things, requires Starbucks to reinstate the fired employees. To assess whether the board was entitled to a preliminary injunction under Section 10J, the district court applied the two-part test established by Sixth Circuit precedent. That test asks whether there is reasonable cause to believe that unfair labor practices have occurred, and whether injunctive relief is just and proper. The board could establish reasonable cause by simply showing that its legal theory was substantial and not frivolous. And, relief would be just and proper if it were necessary to return the parties to the status quo pending the board's proceedings in order to protect the board's remedial powers under the NLRA. Applying this standard, the district court granted an injunction to the board. And, applying circuit precedent, the Sixth Circuit affirmed. Not all courts evaluate petitions for Section 10J injunctions under the standard applied by the Sixth Circuit. Some courts instead apply the four-part test for preliminary injunctions articulated in Winter v. Natural Resources Defense Council Incorporated. That familiar standard requires a plaintiff to make a clear showing that he is likely to succeed on the merits, that he is likely to suffer irreparable harm in the absence of preliminary relief, that the balance of equities tips in his favor, and that an injunction is in the public interest. We granted certiorari to resolve the circuit split about what standard governs the board's requests for preliminary injunctions under Section 10J, and now vacate and remand. Section 10J authorizes a federal district court to grant such temporary relief as it deems just and proper during the pendency of the board's administrative proceedings. When Congress empowers courts to grant equitable relief, there is a strong presumption that courts will exercise that authority in a manner consistent with traditional principles of equity. For preliminary injunctions, the four criteria identified in Winter encompass the relevant equitable principles. Nothing in Section 10J displaces the presumption that those traditional principles govern. We therefore conclude that district courts must use the traditional four-part test when evaluating the board's request for a preliminary injunction under Section 10J. A preliminary injunction is an extraordinary equitable remedy that is never awarded as of right. Its purpose is merely to preserve the relative positions of the parties until a trial on the merits can be held. The default rule is that a plaintiff seeking a preliminary injunction must make a clear showing that he is likely to succeed on the merits, that he is likely to suffer irreparable harm in the absence of preliminary relief, that the balance of equities tips in his favor, and that an injunction is in the public interest. These commonplace considerations applicable to cases in which injunctions are sought in the federal courts reflect a practice with a background of several hundred years of history. When interpreting a statute that authorizes federal courts to grant preliminary injunctions, we do not lightly assume that Congress has intended to depart from established principles. This court has consistently employed this presumption when interpreting a wide variety of statutes that authorize preliminary and permanent injunctions. Thus, absent a clear command from Congress, courts must adhere to the traditional four-factor test. Nothing in the text of Section 10J overcomes the presumption that the four traditional criteria govern a preliminary injunction request by the board. Section 10J authorizes a district court to grant the board such temporary relief as it deems just and proper. We do not understand the statutory directive to grant relief when the district court deems it just and proper to jettison the normal equitable rules. To the contrary, the phrase just and proper invokes the discretion that courts have traditionally exercised when faced with requests for equitable relief. As a matter of ordinary meaning, the word just means fair and righteous, and the word proper means appropriate, suitable, or correct. Crafting fair and appropriate equitable relief necessitates the exercise of discretion, the hallmark of traditional equitable practice. This court's precedent also counsels against reading Section 10J to supplant the traditional equitable principles governing injunctions. The court interpreted the Emergency Price Control Act of 1942's instruction that an injunction shall be granted if the Office of Price Administration shows that a defendant has engaged or is about to engage in a prohibited act. This language is far more favorable to the agency than Section 10J because it seemingly suggests that courts must grant injunctive relief where the agency makes the required showing. Yet, the court refused to read the Emergency Price Control Act to create such a major departure from the long tradition of equity. The court reasoned that if Congress desired to make such an abrupt departure from traditional equity practice, it would have made its desire plain. If the Emergency Price Control Act did not displace the presumption that traditional equitable principles apply, then Section 10J's discretion inviting directive to grant injunctive relief as district courts deem just and proper does not either. Finally, Section 10J's text bears no resemblance to the language that Congress has employed when it has altered the normal equitable rules. Some statutes increase the burden for obtaining an injunction. Another provision in the NLRA itself makes it harder for the government to obtain an injunction against union strikes and lockouts by requiring a showing that the strike or lockout affects an entire industry or a substantial part thereof and imperils the national health or safety. Courts evaluating preliminary injunction requests under the Prison Litigation Reform Act must give substantial weight to any adverse impact on public safety or the operation of a criminal justice system. Other statutes expressly relieve the party moving for an injunction from showing that they can satisfy one of the traditional criteria. For instance, plaintiffs alleging trademark violations are entitled to a rebuttable presumption of irreparable harm upon a finding of likelihood of success on the merits. Unlike these statutes, Section 10J omits any specific instruction that suggests Congress altered the traditional equitable rules. It simply invites courts to grant equitable relief where they deem it just and proper. And, in exercising this discretionary authority, courts must be guided by sound equitable principles. In sum, because nothing in Section 10J's text overcomes the presumption that traditional equitable principles govern, district courts considering the board's request for a preliminary injunction must apply the Winter Framework, which embodies those traditional principles. Rather than contest that traditional equitable criteria govern, the board recasts the dispute as one about how statutory context informs the application of those criteria. The board highlights that Congress made the board, not federal courts, responsible for adjudicating charges of unfair labor practices in the first instance and that courts of appeals must review the board's final decisions deferentially. According to the board, these contextual considerations require district courts evaluating Section 10J petitions to apply the traditional criteria in a less exacting way, and the reasonable cause standard appropriately accounts for context. We disagree. The reasonable cause standard goes far beyond simply fine-tuning the traditional criteria to the Section 10J context. It substantively lowers the bar for securing a preliminary injunction by requiring courts to yield to the board's preliminary view of the facts, law, and equities. Nowhere is this more evident than with what the board, as movement, must show about the merits of its claims. Under the traditional standard, the board would have to make a clear showing that it is likely to succeed on the merits. And, in assessing that likelihood, a district court must evaluate any factual conflicts or difficult questions of law. By contrast, the board may obtain a Section 10J injunction under the reasonable cause standard by merely showing reasonable cause to believe that unfair labor practices have occurred. The board need not convince the court of the validity of its theory of liability, as long as the theory is substantial and not frivolous. And, in reviewing the supporting facts, a district court may not resolve conflicting evidence or make credibility determinations. There is an obvious difference between having the board show that it is likely to succeed on the merits and having it show only that its theory of the case is substantial and not frivolous, without having to convince the court that its theory is likely meritorious. In fact, it is hard to imagine how the board could lose under the reasonable cause test if courts deferentially ask only whether the board offered a minimally plausible legal theory, while ignoring conflicting law or facts. As Judge Riedler explained, if the reasonable cause standard were applied in the traditional civil litigation setting, any complaint that could withstand Rule 12b-6 would automatically be deserving of injunctive relief as well, rendering the court more a spectator than a referee when it comes to matters of equity. Perhaps unsurprisingly, courts that apply the reasonable cause standard freely acknowledge that the threshold merit showing is significantly lower than a requirement to show likelihood of success under the traditional standard. Section 10J's statutory context does not compel this watered-down approach to equity. The board and the partial dissent are correct that Section 10J proceedings are different from ordinary preliminary injunction proceedings insofar as the board, not the district court, will adjudicate the claims in the first instance. But they do not explain why this difference should matter. The board suggests that district courts risk supplanting its adjudicatory authority by conducting an independent assessment of the merits and equitable factors. But, no matter how searching the district court's merits inquiry or what evidence it considers or credits, the board remains free to reach its own legal conclusions and develop its own record in its administrative proceedings. Also, since irreparable harm and the other equitable factors are not part of the unfair labor practice claim, the district court's assessment of those factors is completely irrelevant to the board's adjudicatory authority. The board and the partial dissent also reason that district courts should apply a deferential standard because the board's final decisions are reviewed deferentially by a court of appeals. But, none of the views advanced in a Section 10J petition represent the board's formal position. They are simply the preliminary legal and factual views of the board's in-house attorneys who investigated and initiated the administrative complaint. And, deference to what is nothing more than an agency's convenient litigating position is entirely inappropriate. The board's attempt to salvage the reasonable cause standard using statutory context thus fails. For the foregoing reasons, we hold that district courts must apply the traditional 4 factors articulated in Winter when considering the board's requests for a preliminary injunction under Section 10J. We therefore vacate the judgment of the Court of Appeals and remand the case for further proceedings consistent with this opinion. It is so ordered. Justice Jackson, concurring in part, concurring in the judgment, and dissenting in part. When Congress entrusts to an equity court the enforcement of prohibitions contained in a regulatory enactment, it must be taken to have acted cognizant of the historic power of equity to provide complete relief in light of the statutory purposes. Accordingly, when interpreting a statute that authorizes equitable relief, like a preliminary injunction, this court typically employs what amounts to a two-part inquiry focused on congressional intent. First, we determine whether Congress has stripped courts of their traditional equitable discretion by a clear and valid legislative command. Second, if no such clear command is found, we look to the statutory context to assess how courts should exercise their equitable discretion, as conditioned by the necessities of the public interest which Congress has sought to protect. Today, the court correctly applies the first step, but ignores the second. I agree with the majority that nothing in the National Labor Relations Act, NLRA, clearly strips courts of their equitable discretion to determine whether to issue a so-called Section 10J injunction. And I concur in the conclusion that we should vacate and remand for the Sixth Circuit to reevaluate this case under our traditional four-factor test for assessing requests for preliminary injunctions. But I cannot join the majority in ignoring the choices Congress has made in the NLRA about how courts should exercise their discretion in light of the National Labor Relations Board's authority over labor disputes. Because the majority chooses the simplicity of unfettered judicial discretion over the nuances of Congress's direction, I respectfully dissent in part. The question in this case is how district courts should evaluate the board's request for a preliminary injunction in light of Congress's intentions. The majority suggests a sharp dichotomy: either courts retain all of their equitable discretion, or the board gets undue deference. But, when Congress invokes the Chancellor's conscience to further transcendent legislative purposes, what is required is the principled application of standards consistent with those purposes, not unbridled equitable discretion, which varies like the Chancellor's foot. Our Hecht case is instructive, for it establishes the framework we have long used to assess whether an injunction authorized by a statute should issue. In Hecht, the court was asked to determine whether the Emergency Price Control Act's direction that an injunction shall be granted after a violation was found displaced a court's equitable discretion. As the majority acknowledges, after finding no clear indication that Congress intended to displace equitable discretion, the Hecht court concluded that the answer was no. But Hecht did not end there. The court emphasized that the mere fact that the Emergency Price Control Act lacked an unequivocal statement displacing courts' equitable discretion did not imply that courts should administer the act grudgingly. Instead, the court explained, courts should see themselves as partners of the agency that administered the act. Congress entrusted each with a share of responsibility for effectuating its goals. In other words, court and agency are the means adopted to attain the prescribed end, and so far as their duties are defined by the words of the statute, those words should be construed so as to attain that end through coordinated action. Therefore, a court's discretion must be exercised in light of the large objectives of the act. Hecht's two-step framework is still in use today. We only rarely find that a statute clearly displaces courts' equitable discretion. So, in most cases in which equitable relief is authorized by statute, the movement must contend with the court's equitable authority. In statutes that involve preliminary injunctive relief, that means the party seeking relief must establish 1. That he is likely to succeed on the merits, 2. That he is likely to suffer irreparable harm in the absence of preliminary relief, 3. That the balance of equities tips in his favor, and 4. That an injunction is in the public interest. Even so, under the Hecht framework, we have consistently held that courts' exercise of equitable discretion is informed by congressional intent. Put simply, a court sitting in equity cannot ignore the judgment of Congress, deliberately expressed in legislation. For each of the four factors, then, courts must look to the choices made by Congress for guidance. Once Congress, exercising its delegated powers, has decided the order of priorities in a given area, it is, for the courts to enforce them when enforcement is sought. Here, the choices Congress has made regarding how labor disputes are to be resolved, including its decision to authorize preliminary injunctive relief in some circumstances, are clear and comprehensive. As briefly explained below, Congress has long sought to contain the unbounded exercise of judicial discretion to issue injunctions in the context of labor disputes, leaving the resolution of those particular conflicts primarily in the hands of the board. That is for good reason. To put it bluntly, courts exercising their equitable discretion amidst labor disputes today do so against the backdrop of an ignominious history of abuse. In the early part of the 20th century, the federal courts generally were regarded as allies of management in its attempt to prevent the organization and strengthening of labor unions. Injunctions figured in virtually every railroad strike. In most strikes in which industrial unionism, amalgamation, or federation was at issue, in most major organizing and recognition strikes, boycotts, closed shop or sympathy strikes or anti-union/open shop lockouts of significant magnitude, and in a small but still significant and growing portion of ordinary mine-run strikes. In this industrial struggle, the injunction became a potent weapon that was wielded against the activities of labor groups. Congress reacted to this anti-democratic government by injunction by seeking to cabin courts' power to intervene. Its initial attempt, in the Clayton Act of 1914, was unsuccessful, due in large part to judicial frustration of congressional intent. Its next attempt, the Norris-LaGuardia Act of 1932, was impossible to ignore. There, Congress deprived the courts of jurisdiction to issue an injunction in any case involving or growing out of a labor dispute, except under specified circumstances and with particular procedural checks. 3 years later, in 1935, Congress passed the National Labor Relations Act. The act aimed to eliminate the causes of certain substantial obstructions to the free flow of commerce by protecting workers' rights. To achieve this aim, the NLRA codified employees' right to self-organization, to form and join unions, to collectively bargain, and to strike. It also made it unlawful for employers and unions to engage in particular unfair labor practices. Employers, for example, cannot interfere with employees' efforts to organize a union or engage in collective bargaining. Similarly, unions cannot, inter alia, coerce employees to join a union or refuse to engage in collective bargaining. Notably, though, Congress did not leave it to courts to protect the rights established in the NLRA. Instead, Congress created an expert agency, the National Labor Relations Board, to investigate, adjudicate, and stop unfair labor practices. The agency is headed by a 5-member board that is charged with resolving unfair labor practice cases. The enforcement role is occupied by a general counsel. The general counsel is charged with investigating and prosecuting unfair labor practice cases, as well as overseeing regional offices that carry out much of the day-to-day work of enforcing labor law and policy. To evaluate and remedy unfair labor practices, the board follows a 4-step process. First, a charge is filed and investigated, with parties generally permitted to present evidence and arguments related to the alleged violation. Second, if the investigation yields sufficient information to show an unfair labor practice, the regional director can issue a complaint. Third, an administrative law judge holds a hearing and issues a decision on the merits of the complaint, which a party can then appeal to the board. Finally, if the unfair labor practices alleged in the complaint are sustained, the board can seek enforcement of the order, and any aggrieved party can seek review in a federal court of appeals. Crucially, for present purposes, Congress recognized that delay in vindicating labor rights during the notoriously slow course of NLRB proceedings can lead to their defeat. This case illustrates the problem. In February 2022, Starbucks fired 5 of 6 members of an organizing committee, along with 2 other union-aligned workers, just as a campaign for unionization was building momentum. The board took up the workers' complaint soon after. Now, more than 2 years later, their case remains pending. To respond to situations like this, Congress gave the board specific power to seek preliminary injunctive relief. These injunctions are generally referred to as Section 10J injunctions, named after the section of the Taft-Hartley Act of 1947 in which they were originally introduced. There is broad consensus about why Congress allowed the board to seek Section 10J injunctions. As summarized in the Senate report on Taft-Hartley, time is usually of the essence in labor disputes, and the relatively slow procedure of board hearing and order, followed many months later by an enforcing decree of the Circuit Court of Appeals, falls short of achieving the desired objectives, the prompt elimination of obstructions to the free flow of commerce and encouragement of free and private collective bargaining. Therefore, Congress provided that the board, acting in the public interest and not in vindication of purely private rights, may seek injunctive relief in all types of unfair labor practices. In short, Congress designed Section 10J as a means of preserving or restoring the status quo before the onset of unfair labor practices so that the board's ultimate ability to remedy an unfair labor practice would not be impeded. In addition to authorizing Section 10J injunctions, Congress made 2 other pertinent choices in the statute. First, it granted the board power to seek a Section 10J injunction. No private party has authority to seek Section 10J relief, and by the statute's terms, the power is left to the board itself rather than the general counsel or another member of the agency's prosecutorial branch. This is unlike a closely related section of the statute, Section 10L, which authorizes the relevant officer or regional attorney to file for preliminary relief in cases involving certain unfair labor practices by unions. Second, Congress granted the board discretion to determine whether or not to seek preliminary injunctive relief. Thus, the board only needs to seek Section 10J relief when it deems doing so appropriate or necessary. By contrast, requests for relief under Section 10L are mandatory once an investigation yields reasonable cause to believe an unfair labor practice has occurred. The NLRA does not specify how the board should exercise its discretion to seek Section 10J injunctions, but the agency has created a standard operating procedure. First, the regional director must submit a written memorandum to the General Counsel explaining why temporary relief is appropriate in a given case. Second, the General Counsel must review the memorandum and determine if the request for relief is warranted. Third, if the General Counsel determines that a Section 10J injunction should be sought, she must present a recommendation to the board. Finally, the board must accept or reject the recommendation. Only after the board approves the filing of a request for a Section 10J injunction does the General Counsel or relevant regional director file that request in federal district court. When the district court receives the board's application for a Section 10J injunction, the statutory scheme kicks back in. Upon filing such a petition, the court has jurisdiction to grant the board temporary relief or a restraining order as it deems just and proper. If granted, a Section 10J injunction returns workers, unions, and employers to the status quo as it existed before the alleged NLRA violation. What standard should district courts use to decide whether granting the board's Section 10J request for interim relief is just and proper? This case presents that question, and we use Heck's framework to answer. First, we determine whether Congress has clearly displaced courts' equitable discretion. Second, if no clear statement exists, we evaluate how that discretion should be exercised in light of Congress's choices in the NLRA. At Step 1, the parties do not dispute that Section 10J's text, context, and legislative history lack the clear congressional intent required to preclude district courts from exercising equitable discretion. Also, no circuit holds that Section 10J deprives district courts of their equitable discretion. I agree with the majority that courts faced with a board petition for a Section 10J injunction should evaluate that request using all four factors in the established Winter test. The remaining question, Heck's second step, is more challenging. The majority has done an insufficient job of explaining how district courts' equitable discretion is channeled by Congress's choices within the NLRA. The need for this is uncontroversial. Starbucks argues that statutory context is relevant to the consideration of equitable relief, and every relevant circuit, including those that use the standard four-factor test, understands district courts' equitable discretion to issue a Section 10J injunction must be informed by the NLRA's statutory context. However, the court today provides little helpful guidance on this front. Given our precedents and the statute's text, the interaction between Congress's choices in the NLRA and a district court's equitable assessment of a request for Section 10J relief is straightforward for three of the four equitable factors. To show irreparable harm, the board must establish that its ability to remedy a violation of labor rights will likely be precluded absent interim relief. When evaluating the balance of the equities, district courts may consider harms to an opposing party, but they are prohibited from crediting a party's desire to continue engaging in an alleged violation of the NLRA. When addressing the public interest, courts must defer to Congress's articulation of that interest in the NLRA itself. The final factor, the likelihood of success on the merits, is more difficult to evaluate. That factor can be articulated in a variety of formulations but, at core, it asks courts to predict how likely it is that a party seeking preliminary relief will ultimately prevail on the merits of their claims. In my view, three aspects of the NLRA's scheme should inform this evaluation. First, as described above, the NLRA makes the board, not district courts, the primary adjudicator of labor disputes and the central expositor of labor policy. This means that, unlike in the typical preliminary injunction context, the district court is not making a predictive judgment about how it will rule on the merits itself. Instead, the court is predicting the future decision of the board. Second, as I previously explained, Section 10J empowers the board, acting in its adjudicatory capacity, to seek injunctive relief. When it does so, the board is not acting as a party to the underlying dispute. We also have evidence that the board's screening process for determining when to seek a Section 10J injunction is exceedingly rigorous. Of the roughly 20,000 unfair labor practice charges filed last year, the board authorized the filing of a petition for Section 10J relief only 14 times. This means that by the time the district court gets a rare Section 10J request, the board has already deemed an unfair labor charge likely meritorious, and has determined that preservation of the status quo is needed to facilitate its own likely judgment. Finally, The NLRA gives federal courts only a limited role in reviewing the board's decisions. In the Court of Appeals, the board's factual findings are conclusive if supported by substantial evidence. We have also long recognized that the board's legal interpretations are to be accorded considerable deference. What is more, absent highly unusual circumstances, district courts play no role in the review process at all. These three features of the statutory scheme necessarily mean that a district court's preliminary look at the merits when considering the board's petition for interim relief under Section 10J should be far less searching than normal. A Section 10J injunction request simply does not present the district court with an opportunity to wade into the midst of an ongoing labor dispute, over which it otherwise has no say, and offer its own take about how the merits should be decided. Instead, in deference to Congress's choices as codified in the NLRA, the district court's task is much simpler: to evaluate a petition for a Section 10J injunction in a manner that accounts for the statutory scheme authorizing such relief and the district court's proper role within it. Thus, so long as the board has presented some evidence to support the unfair labor practice charge, together with an arguable legal theory, a district court should find this final factor satisfied. The majority's contrary conclusion on the likelihood of success factor is based on various misrepresentations about the board's authority under the NLRA. For example, in addition to mistakenly consigning the board to the status of a mere party mouvant, the majority misstates the board's role in seeking Section 10J relief generally. Similarly, the majority misrepresents the board's arguments in this case regarding how the statutory scheme informs district courts' analysis. Far from failing to explain the relevance of district courts' lack of jurisdiction over labor disputes, the board has offered a detailed argument, consistent with our precedent and the long-standing decisions of the lower courts, for why this structural feature of the NLRA is important and why it might well be dispositive of the likelihood of success analysis. The majority also completely misses the significance of the limited role that federal courts of appeal play in reviewing the board's decisions. Unfortunately, today's decision appears to be another installment in a series of labor cases in which this court has failed to heed Congress's intent with respect to the board's primary role in adjudicating labor disputes, and, like its earlier decisions, the court's ruling is likely to cause considerable confusion among the lower courts, which have been for decades exercising their equitable discretion informed by the NLRA. I recognize that, as a practical matter, the majority's decision here may make little difference, since requests for Section 10J relief are rare, but that fact is more a function of the board's gatekeeping role than anything else. Now that the court has concluded the board's authorization to seek Section 10J interim relief is of no moment, the board may find it unnecessary to play the gatekeeping role Congress designed for it in this context. As a result, today's decision might force not just courts, but also the board, to disregard Congress's direction. A petition for Section 10J relief serves a straightforward but significant purpose: to preserve the NLRB's remedial power while the board resolves an unfair labor practice charge. Today, the majority casts a district court's decision regarding a Section 10J request as one that invokes the full sweep of a court's traditional equitable discretion, without regard for the board's authority or the statutory scheme that authorizes courts to issue such interim relief in the first place. In doing so, the court unnecessarily and casually substitutes the chancellor's clumsy foot for the rule of law. I am loath to bless this aggrandizement of judicial power where Congress has so plainly limited the discretion of the courts, and where it so clearly intends for the expert agency it has created to make the primary determinations about both merits and process. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. The summary of this opinion given in the introduction was taken from the summary provided at oyez.org. Any mistakes in the opinion you just heard should be attributed to this podcast. If you would like to support my efforts to make Supreme Court opinions available to the public, please subscribe. Thank you.